Hi, my name is Arielle Montijo. I have really enjoyed this class and the topics we've covered. I learned a lot and will definitely be using the information in everyday life, especially when I start my working career in human resources. Today I will discuss sexual harassment under California law. It is a topic that everyone, especially those in the workforce, should know about. There is a ton of history surrounding this issue, and there are laws that aim to protect people in the workplace. A lot of these laws are topics that we discuss a lot and we've heard a lot about in our school lives. One of them being the Equal Pay Act of 1963. This law makes it illegal to pay different wages to men and women if they perform equal work in the same workplace. This law also makes it illegal to retaliate against a person because the person complained about discrimination, filed a charge of discrimination, or participated in an employment discrimination investigation or lawsuit. Probably the most popular law or act is the Title VII of the Civil Rights Act of 1974. This law makes it illegal to discriminate against someone on the basis of race, color, religion, national origin, or sex. The Age Discrimination in Employment Act of 1967 protects people who are 40 or older from discrimination because of their age. This law also makes it illegal to retaliate against a person because the person complained about discrimination, filed a charge, or participated in an employment discrimination investigation or lawsuit. The Americans with Disabilities Act of 1990 makes it illegal to discriminate against a qualified person with a disability in the private sector and in state and local governments. So these are just some of the laws that we have discussed that help people and protect people from being discriminated against at work. Another popular bill is Bill 76. It makes employers liable for any sexual harassment encountered by their employees in the workplace, including treatment by customers and vendors. Bill 1825 requires employers in California with 50 or more employees to provide supervisors at least 2 hours of sexual harassment training every 2 years. So what is exactly sexual harassment? It is defined as unwelcome sexual advances, requests for sexual favors, other verbal, visual, or physical conduct of sexual nature when submission to such conduct by an individual is made explicitly or implicitly a term or condition of employment. Submission to or rejection of such conduct by an individual is used as the basis for an employment decision. And lastly, the conduct has the purpose or effect to mess with an individual's work performance or creates a hostile or intimidating environment. Offensive conduct may include, but is not limited to, offensive jokes, slurs, name-calling, physical assault or threats, intimidation, ridicule or mockery, and insults. I'm aware that my topic is California law, sexual harassment, but we will talk a little bit about the two types of protection. For example, the federal level, the Title VII of the Civil Rights Act of 1964 prohibits discrimination based on race, color, religion, national origin, gender/sex, even childbirth too, and it is enforced by the EEOC. For the state level, California Fair Employment and Housing Commission prohibits harassment based on sex or of a sexual nature, gender harassment, harassment based on pregnancy, childbirth, or related medical condition. This may include multiple forms of offensive behavior, including harassment of a person of the same gender as the harasser. It's not just about sex. Sexual harassment is what we hear about probably most often, but there are other forms of harassment that are just as serious. This can include a person's race, their color, religion, national origin, gender, disability, age, or sexual orientation. In 2012, there were some new laws brought up in California. Assembly Bill number 887 has redefined gender to include a person's gender identity, how an individual sees their gender, gender expression, a person's gender-related appearance and behavior. Assigned sex at birth generally has no bearing. This requires employers to allow employees to dress consistently with the employee's gender identity and gender expression. This bill and the entire topic of gender identity or gender expression is something we hear a lot about in today's society. Especially being in San Francisco, we have real-life examples of this often. In popular culture, of course, we have Bruce Jenner, who most recently, famously, the former Olympian, went from a man to a woman last year, and it's very public, and I think the topic is very talked about, and it's something that we need to educate ourselves on, and people in the workforce especially need to know about this and become accepting. Quid pro quo harassment is the most prominent form of harassment. It is derived from Latin, and it means basically this for that. It involves expressed or implied demands for sexual favors in exchange for some benefit or to avoid some detriment in the workplace. For example, a supervisor tells an employee in his department that she can have a raise if she sleeps with him. By definition, it can be perpetrated only by someone in a position of power or authority over another. What is a hostile environment? What is okay to one person might not be okay to another. It is defined as sexual or other discriminatory conduct that is so severe or pervasive that it interferes with an individual's ability to perform their job. It can be perpetrated by anyone in the workforce environment, including a peer, supervisor, subordinate, vendor, customer, or contractor. Conduct must be unwelcome, directed toward a protected category, offensive to a reasonable person, and severe or pervasive. You might ask, what is a reasonable person standard? Basically, would a reasonable person find the conduct offensive? It does not matter if the person intended it to be funny, others thought it was funny, the person complaining seemed to go along at the time. A great example of this would be the Miami Dolphin football case in 2013. The victim, Jonathan Martin, was being bullied by Mike Pouncey, his teammate, and other players on the team, whom he even had a friendship with, went on trips with, and they thought that he was just going along with it. But he was actually suffering at home and was complaining to his mom and stuff like that, and he didn't really speak up until after the fact. But even though he didn't say anything or necessarily tell them, hey, stop, it was still wrong, and they were wrong on their part. So how do we necessarily know if conduct is unwelcome? Well, some people might seem like they're not bothered. They very well could be. Some signs that pop up that will show or let somebody know that an employee is not liking the conduct are the employee will complain, there will be some type of verbal response or even lack thereof. The individual will show expression changes, body language will appear different, the person will look uncomfortable and tend to avoid others. Recently I had a close friend of mine experience something like this at work where her mentor, she was a special education teacher, and the psychologist who basically oversaw her work was sending her some pretty sexual emails, and she kept telling him no, but she was a little afraid because he was a higher position than her. He was on the city council in the town that the school was in, so she was a little afraid to speak up. She was a little disconnected from all her normal activities at home and her friends, and it was affecting her work, and she was really stressed out about going to work. So these are signs that people have to look out for and just try to get a feel of what's going on in the workplace. All employers are prohibited from harassing employees in the workplace. If harassment occurs, an employer may be liable even if management was not aware of the harassment. An employer might avoid availability if the harasser is a non-management employee. The employer had no knowledge of the harassment. and there was a program to prevent harassment. If the harasser is a non-management employee, the employer may avoid liability if the employer takes immediate and appropriate corrective action to stop the harassment once the employer learns about it. Employees are strictly liable for harassment by their supervisors or agent. The harasser can be held personally liable for damages. Additionally, Government Code Section 12940 requires an entity to take all reasonable steps to prevent harassment from occurring. If an employer has failed to take such preventative measures, that employer can be held liable for harassment. A victim may be entitled to monetary damages even though no employment opportunity has been denied and there is no actual loss of pay or benefits. So basically the employer is liable. They have to make sure they take all the proper precautions. They do what they need to do. They can't just avoid this problem, because if they tend to avoid it, it could turn into a bigger thing, and it could have been something that was solved or, like I said, prevented in the first place. What are the obligations of the employer? Well, technically, all employers have a legal obligation to prevent sexual harassment. Employers must take all reasonable steps to prevent discrimination and harassment from occurring. Even though the employer might think, this won't happen at my workplace, everyone gets along, we don't live in a fantasy land, we live in reality where things happen, people say stuff, people snap, and people's feelings can change from day to day, so you have to make sure you take all the proper precautions. Employers must help ensure a workplace free from sexual harassment by posting in the workplace a poster or a flyer made available by the Department of Fair Employment and Housing. They have to do what they have to do to show it. Just like at a school, how they have the school standards or the school anthem or what the school believes in set up for people to see. This is what the employer must do. They have to know that they have a stand against this and they won't tolerate it in their workplace. When it comes to enforcement of the law, employees or job applicants who believe that they have been sexually harassed may, within 1 year of the harassment, file a complaint of discrimination with the California Department of Fair Employment and Housing. The department will investigate the complaint and attempt to resolve the disputes. If the department finds evidence of sexual harassment and settlement efforts fail, the department may file a formal accusation against the employer and the harasser. The accusation may lead to either a public hearing before the Fair Employment and Housing Commission or a lawsuit filed on the complaint's behalf by the department. If the commission finds that harassment occurred, it can order remedies including up to $150,000 in fines and/or damages for emotional distress from each employer or harasser charged. In addition, the commission can order hiring or reinstatement, back pay, promotion, training, and changes in the policies or practices of the involved employer. The court could possibly order unlimited damages. So now that we've established that every employer is responsible for preventing sexual harassment, what do they need to do to make that happen? For example, when I had to work with kids, when I was a few years younger, I worked at a kids camp. I was forced to do this training called Shield the Vulnerable. It was an online training. It was about 2 hours. And basically we just went over a lot of topics and what we needed to do in case something happened. But basically it was a preventative workshop, and I thought it was really helpful and it gave me a lot of good useful information. So something like that would definitely be beneficial to organizations or employers to use, because like I've said over and over, you want to do your best to prevent stuff like this from happening, but realistically it probably will. A program to eliminate sexual harassment from the workplace is not only required by law, but it is the most practical way to avoid or limit damages if harassment should occur despite preventative efforts. Every single employee must receive from their employers a copy of the pamphlet titled "Sexual Harassment is Forbidden by Law," or a document of similar nature. Employees should be made aware of the seriousness of violations of the sexual harassment policy. Supervisor personnel should be educated about their specific responsibilities. Rank and file employees should be cautioned against using peer pressure to discourage harassment by victims from using internal grievance procedure. Employers with 50 or more employees must provide at least 2 hours of classroom or other effective interactive training and education regarding sexual harassment to all employees who are employed as of July 1st, 2005, and to all new employees. So a lot of people probably will think, I don't need to take this training. I'm not going to do that. There's no chance I'll ever take something serious that someone says. But it is the responsibility of the employer to make sure that this is something that every employee goes through. I know the saying should be used here, it's better to be safe than sorry. Employers must help ensure a workplace free from sexual harassment by distributing to employees information on sexual harassment. An employer may either distribute a brochure that may be obtained from the Department of Fair Employment and Housing, or develop an equivalent document which must meet the following: the illegality of sexual harassment, the definition of sexual harassment under state and federal laws, and a description of sexual harassment using examples. A lot of people might not know what is considered sexual harassment. They may think it's just a funny joke because they say it at home or with their friends, but it might not be acceptable to people, especially in the workforce, and they have to be informed that even something that they think is a joke or, something from a movie or a song, it could be taken offensively from somebody else. So once a sexual harassment problem happens, there tends to be a lawsuit. An average of 450 employment lawsuits are filed daily in the United States. Wow, that's a lot. California leads the nation in employment law claims. When sued, a company will lose the case more than half of the time. In 2010, the EEOC filed 250 new lawsuits and resolved 285 pending lawsuits. In 2011, the EEOC filed 261 new lawsuits, resolving 276 pending ones. In 2012, the EEOC filed 122 new lawsuits, resolving 254 pending lawsuits. To me, that sounds like a lot of lawsuits, and I think a lot of this could be prevented if employers actually give the training or a brochure like we just talked about. 3 most common types of sexual harassment complaints filed: an employee is fired or denied a job or an employment benefit because he or she refused to grant sexual favors or because he or she complained about harassment. Retaliation for complaining about harassment is illegal, even if it cannot be demonstrated that the harassment actually occurred. An employee quits because he or she can no longer tolerate an offensive work environment referred to as a constructive discharge harassment case. If it is proven that a reasonable person, under like conditions, would resign to escape the harassment, the employer may be held responsible for the resignation as if the employee had been discharged. An employee is exposed to an offensive work environment. Exposure to various kinds of behavior or to unwanted sexual advances alone may constitute harassment. We are living in a time when a lot of these topics are being discussed. Recently, I was watching the Republican National Convention and the Democratic National Convention, and at the DNC, I heard a lot about fairness aimed towards everyone, and Hillary Clinton had a lot of people speak, and one of them was a woman with disabilities, and they talked about the Americans with Disabilities Act, and I think it's just, this whole issue is something that we need to teach and inform people about, And we need to start it at a young age, even possibly in the elementary schools, just letting people know what is right and what is wrong. Um, and that people take offense to different things, and you have to, it's kind of sad, but you kind of have to be careful of what you say, and you have to know your audience at all times. So these are my references used. A lot of it I used from personal real life experiences I had learned or heard about. All these references, though, that I used were very helpful and aided me in this practicum. Thank you for listening, and I hope your understanding of this issue grew. I know that I definitely learned a lot, and will use this information once I become an HR professional. And have a great day and a great summer, and thank you very much.